Hello everyone, welcome to StudyIQ IAS English. My name is Pravin Mishra and today we are going to discuss about another question mark on our federal structure. Well, yes, from the words of K.C. Weary, India, that is we, are not federal, we are quasi-federal. And this basically explains that in India, powers are not equally shared between the center and the states. Here, center is more powerful. And one such office that gives more tilt or more weightage towards the union part is the office of governor under Article 153. Well, governor, who has been often called as the agent of center within the states. And now this office has created a big question mark inside the state of Tamil Nadu with regard to the federal structure or the quasi-federal structure we do have. Well, the question here, what the state government of Tamil Nadu raised in front of the Supreme Court, in the courtroom basically, that are these governors acting as the super chief minister by delaying to the assent of the bills sent to them by the honorable state legislative assemblies? Is this the fact, and is this constitutionally permitted, and is this constitutionally correct, constitutionally, ethically, as well as with regard to the political as well as moral suasion? These are the questions which the state government of Tamil Nadu has raised in front of the Supreme Court, that really, do you think, are these governors acting as what? Acting as the super CMs, the super chief ministers. So what basically is the question? What basically is the concern? See, whenever the bill which is passed by the state legislative assembly is sent to the governors of the state for their assent. So in that condition, using Article 200, the governors of the state have got multiple options, like giving the assent to the bill, withholding the assent, sending the bill for the reconsideration of the assembly, or even sending the bill to the president for his or her consent. And now this raises the question that in what time, minimum to maximum, what time the governors must perform any of those such activities, whether to give the assent, withhold the assent, resend the bill for reconsideration, or send the bill for the presidential assent. Is there any minimum to maximum time limit prescribed in our constitution? Well, the answer is no. And here is the concern with regard to the same. So the one-line statement that we need to understand here, whether the state governor may sit on, that is basically indefinitely withhold or reserve the bills passed by a state legislature, effectively acting as the super chief minister, and whether the governor and the president must discharge their functions under Article 200 and 201, 200 for governor, 201 for the presidents respectively, functions within judicially manageable time limits. This is what the concern which is raised into this very famous case, now a landmark case in the Indian polity, that is the state government of Tamil Nadu versus the governor of Tamil Nadu. Basically, precisely M.K. Stalin, the CM of Tamil Nadu versus R.N. Ravi sir, the governor of Tamil Nadu. So here are the next features. Article 200, as I stated just a minute back. Whenever a bill is passed by the state legislature and presented to the honorable governor, the governor may first give assent, second, withhold the assent if it is not the money bill, and third, return it for the reconsideration of the assembly, and fourth, can also send the bill for the assent of the president. And Article 201, if a bill is reserved for the president's assent, the president may give the assent, withhold the assent, or direct return again. And now the problem, once again, no, literally you can see, no explicit time limit appears on the face of the articles. That is once again 200 and 201. That is how much time minimum to maximum the governors and the president can keep the bill within themselves. And these texts literally they set the problem. So the constitution prescribes the options for the president and the governors, but not explicit timings, which has produced the litigation as well as the institutional friction. Another question once again on the federal structure of our country. So see the next part, the facts of the Tamil Nadu litigation. So what the state government has actually raised the volume on. So between 2020 to 2023, so roughly a time period of 3.5 years, Tamil Nadu government passed several bills and sent it to the governor. And ultimately what happened? the governor didn't responded on time with regard to the bills, whether sending the bill for reconsideration, sending the bill for the president's assent, or just withholding the bill, something like that. So literally what has happened, okay, so the bills remained inactive, the inaction, and it persisted for many months. And the state challenged this delay as illegal, unconstitutional. And it reached the Honorable Supreme Court, and the court framed that the constitutional questions on Article 200 as well as 201 and competitiveness of the delay should be something that should be taken care of. And here comes the judgment, as you can see. So what the Supreme Court basically held. See, the governor, no doubt, is the ceremonial head. Just like we have got the president at the union level, we have got the governors at the state level. President is bound to act on the aid and advice of the Central Council of Ministers under Article 74, and so are the state governors. They are bound to act on the aid and advice of the State Council of Ministers under Article 163. And now, the question with regard to the time limits. The Supreme Court clearly, in April 2025, in the Governor versus Chief Minister's case, gave the time limits under Article 200 and 201. So, if now the bill is sent to the governor, see, this is not written in the Constitution. This is what Supreme Court has, going ahead with the judicial review concept, gave the interpretation under Article 200 and 201. Not yet written, an amendment is yet to be done. This is simply the interpretation of the Supreme Court that you are watching on your screen. So if a bill is sent to the governor by the state legislative assembly for his or her assent, the governor can keep the bill with himself or herself for a maximum period of 90 days. And within 90 days, the governor will have to tell the assembly that whether he or she is going to give the assent to the bill, whether he or she is going to send the bill back to the assembly for the reconsideration, or is going to send the bill to the Honorable President of India for her assent. So this is what within 90 days. Now let's say within 90 days, the governor responded to the State Legislative Assembly that today I'm returning the bill to you, right? And now you just reconsider my opinion, my advice, my suggestions, okay, and then send the bill back to me. Okay, so that's done. That is what we call it as suspensive veto. So on the second time, when the bill is sent back to the governor, now the governor will have to send the, assent within 90 days again. Okay, now next thing. Let's say the assembly sent the bill to the governor for his or her assent, and governor within 90 days can keep the bill, and at the end of the 90th day, basically, okay, maximum time period, what we can call it, the governor may respond to the assembly that I'm sending the bill for the consideration or for the assent of the president. So president under Article 201 is once again bound to respond to the assembly that yes, whether I'm going to give the assent, whether I'm going to just deny my assent, or I'm going to send the bill back for the reconsideration. So let's say president has sent the bill back for the reconsideration, or president has given the assent. Now president will send the bill back to the governor. So governor can keep the bill with himself or herself for a maximum period of 1 month only. This is what the interpretation under Article 200 and 201 is given by the Supreme Court of India with regard to the assent to the bills passed by the State Legislative Assembly and the roles of governors as well as the president. So as you can see once again here, okay, so if the governor, okay, literally what the court has stated, this is what Supreme Court's guidelines. If the governor must act forthwith, for instance, where a bill is presented again after reconsideration after the first proviso, the governor must grant assent for a maximum period within 1 month. That is 1 month. As per the Constitution, it is 30 days, not 31 days. Second condition, if the governor withholds the assent contrary to the council's advice, council as in State Council of Ministers, okay, he must return the bill together with a message within a maximum period of 3 months. 3 months here once again, 90 days. Remember, as per Constitution, months are calculated from the 30 days parameter, not 31 days. Now, finally, if the governor reserves a bill for the president Contrary to the advice of the State Council of Ministers, the reservation must be made within a maximum period of, once again, 3 months, that is 90 days. And remember, these are the things that are interpreted by the Honorable Supreme Court of India. This is not mentioned inside our Constitution. And failure to do so, failure to act within such time limit will lead to the inquiry against the Honorable Governor and might initiate the judicial review on the same. So failure to act within these time limits renders the Governor's inaction justiciable and susceptible to the judicial review. Right? So this is what has been mentioned by the Honorable Supreme Court of India. Okay? So these time limits were treated as judicially evolved, reasonable, as well as needed, okay, in order to protect the federal fabric of our country, right? So this is what Supreme Court has stated, and this is what presently has also called in the presidential reference under Article 143. The Union government, after such decision or order or judgment of Supreme Court, directly approached the President, and President used her Article 143, that is named as advisory jurisdiction of the Supreme Court, or also the presidential reference. Okay, so President, considering the substantial question of law under Article 143 Clause 1, approached the Supreme Court, where the Attorney General of India represented the government in front of the courtroom in the Supreme Court. And now the question was raised by the Union government that whether such an interpretation by Supreme Court is constitutionally valid or not. Isn't it not type of a judicial outreach or overreach? Come on, guys, what's your opinion on the very same part? Do you think the Supreme Court's judgment is right? There should be a prescribed time limit? Or do you think Supreme Court should have asked the very same thing to be done by the Union Parliament? As this time it is visibly, what we can say, it's a breach to the position that is known as checks and balance, right? So that's what the logic here is. So here we go, guys. Quickly understand the MCQs as well from the same part, from the same topic. That is question number 1 here, okay, for you. So guys, please just pause the video, look forward for the question carefully, and just let us know your correct answer. So this is question number 1. So which of the following statements is or are correct? So you have to tell us the correct answer. Next, second. Recently, the Supreme Court prescribed the timelines for the President and Governors, as we have discussed. Once again, 3 statements, and we have got 4 options. So select the correct code. Okay, everyone. So these are the 2 MCQs related to the topic. So let us know your correct answer into the comment section. And yes, if you are a serious UPSC CSE aspirant, this information is for you. So the resolution batches that are live from 31st of August. And the sale is also live on the same resolution batches if you enroll on or before 31st of August. So remember, guys, what you will get if you enroll yourself in the resolution batch. 1000 plus hours of live classes with access to recorded lectures, 18 sets of printed books sent to you at your doorstep. Along with teacher's personal class notes will be shared with you that he or she is using to teach you at the end of the session. Prelims test series, mains test series, interview guidance program, 1:1 mentorship, as well as the mains residential program. Everything is covered under one single subscription. 75 plus tests for your prelims, 15 plus tests for your mains, multiple mock interviews for your personality test as well. And apart from that, the moment you have subscribed, the very same moment you will be assigned a very personal mentor for you. Personal mentor as in, apart from your teachers, those who are the educators, those who are teaching you in the live classes, you will be also guided by a separate mentor who shall be there for you whenever you need. Okay, you can just ring them up and just ask them that I'm facing such type of doubts, and the mentor can keep a Zoom session or a different type of a session with you where you can sit one-on-one and discuss all of your issues and grievances and get them addressed at the earliest possible time with regard to your academics. Right, everyone? So this is what the beauty of the resolution batches are. And apart from that, yes, the mains residential program, simply speaking, once you have qualified your prelims, you will be called to Delhi's Rajendra Nagar, the hub of civil services, where you will be getting the opportunity to learn from the very same great mentors in the offline mode, those who will be there to train you, prepare you for your next big exam, that is your mains examination, and your accommodation. That is why we call it as residential program. Your accommodation will be totally on us. As in, you don't have to pay a single penny, a single rupee for your PG's rent. Okay, it will be all totally paid by us. You don't have to pay a single penny for that. And it's besides the very same building where our Study IQ offline center is in the Rajendra Nagar. Right, everyone? So this is all you are going to get within just one batch. Okay, and now the price. Let's talk about the price you need to pay for all of such things. It is just rupees 25,999 only, but you will get the discount, you will get the proper maximum possible discount only when you have applied this promo code, that is PRV live. So guys, keep this code copied with you, that is PRV live, okay, and avail the maximum possible discount on all the subscription that you are going to take on these Study IQ platforms. And before you leave, guys, please don't forget to hit the subscribe button of our channel, that is Study IQ IAS English. You know the agenda of the channel quite well, providing you with all the basic content, all the basic information required with regard to the current affairs as well as other static part in your journey of UPSC CSE. So guys, remember, okay, just hit the subscribe button and never miss an update from the channel. And here you can connect with me on my Telegram channel, and here is my Instagram account as well. So wherever you wish, you can connect and let me know if there are any issues and how can I help you. Thank you so much guys for joining. Bye bye. Good day. Take care. Jai Hind.